Hi, everybody. Thank you for attending tonight's Zoom program. I'm April. I'm coming from you from Islin, live in my house. And just make yourself comfortable. We are recording this program. So we right now have all the cameras turned off and the microphones muted. While Ken is talking, we're going to have the microphones muted, but we will have a chat. So I'll monitor the chat. So if you have any questions, you can ask. And maybe at the end of the program, probably at the end of the program, we'll ask for questions as well. Just trying to protect people's privacy by having the microphones turned off and the cameras turned off. Also want to let you know that Ken Vercammen is an attorney in Edison. He is co-chair of the ABA Probate and Estate Planning Law Committee of the American Bar Association Solo Small Firm Division, and he's also the author of the ABA book, Wills and Estate Administration. And you can find out more about him at njlaws.com. So welcome, Ken, and I'm just going to turn it over to you.
Excellent. Thank you, April. I'm waving to everyone who's watching, listening. So my name is Ken Vercammen. Let me fix my tie so I look good. Okay. So we talk, have talks and like, whoa, what's new? Well, there's this thing where like courts are closed, the surrogate's closed. Well, how are we able to keep functioning? Well, way back in March of this year, I'd say we still had people that want to get wills done, but also more importantly, get living wills and powers of attorney done. And then we had a big rush in April because people say the people are in the hospital, you can't even visit them. We need, there goes, I need to get a power of attorney done for me, or I need to get one for dad. Well, we could not go to the hospital, but we could still prepare documents. So how are documents being done? I'd say to assist clients and seniors, my office, other attorneys, we're doing document preparation remotely and consults remotely. So logistically, what we would do is we would email people the interview form and then have them go to their computer and type up some details on the will questionnaire. And during the program, I'll go more into what's in the will questionnaire. And in a way, it made me be much more efficient because what for the prior 30 years, we would mail out by post office the questionnaire, and someone would take a pen and fill it out, and then they'd come in and I'd have to try to figure out what someone's handwriting was. And now the people didn't even have to even come into our office. They could type up the details, email it to us. I'd give them a call. They'd pay by credit card. We'd prepare the documents. We'd email everyone the documents, and we'd email them in a Word format so that if there's something as easy as trying to change the spelling of someone's name because they made a mistake, they could do that. Then the people would print out the documents, and a will has to be signed in front of two witnesses and the notary. Well, a lot of the notaries were closed. Libraries were closed. The banks were closed. However, the UPS store was closed, was open, and they have a notary service. So people were signing their documents in front of the notary at the UPS store with two witnesses. A spouse can be a witness when it's a first marriage situation. So we've been, despite everything, closed, we want people to stay safe, but we get their important documents done. So we strongly recommended have a will, also a power of attorney in the event they became temporarily incapacitated or paralyzed. His office similarly has, you go to the doctor, you would fill out details ahead. Now the doctors are having you type in the information email to them. So we're trying to expeditious as possible for everyone. And we've also been doing remotely living wills with combined advance directives for healthcare. So if someone, a living will is not only, when you think of living will, a lot of people think of, oh, someone's in a coma, irreversible condition. However, also a living will is you're giving a medical power of attorney for healthcare or medical proxy, so that all of a sudden if someone's in the hospital, it gives like the person that they picked the ability to talk to doctors and go over what's best for someone, because sometimes people can't, they can't talk. And everyone makes their own decisions, and it's sometimes it's medical issues. So anyway, let me get into now the main portion of the presentation. People have always asked us, we meet people in events, why do I need to have a will? I'm married. Doesn't everything go directly to my spouse? And I goes, well, I'd say that doesn't, that's not good planning. That's bad planning, because you can't predict when the second person's going to pass away. So let's see, if someone doesn't have a will and they have children, let's say no spouse, well, the process to distribute assets becomes much, much, much more complicated. So let's say there are 3 kids, 4 kids. Well, it would require all the children to select someone or agree upon someone to be the administrator of the estate if there's no will. Then all the children sign a renunciation affidavit in front of a notary agreeing upon who's going to be the administrator. However, if all the children don't sign the renunciation affidavit, then the person who wants to become the administrator would have to file a complaint in order to show cause in the Superior Court. And then there'd be a hearing, a month and a half, 2 months, 3 months in the future. Well, and they're spending over $3,000. Everyone has to be notified if one person doesn't sign it. So certainly having a $300, $400, $500 will would save the family money. Also, if there is no will, then the person who becomes the administrator has to apply for and obtain a surety bond, kind of like an insurance policy, but they're spending $1,000, they don't get the money back. If there's no will, or I always say if the will is declared invalid because it was not properly signed or is not admissible to probate, then state law determines who gets assets, not you. And more people are saying, hey, let's say I don't need to have all my assets go directly to the kids. Many times they'll say, I want to go to the grandkids. My kids themselves are already grown. They have their own house. I want the money to go towards the kids' education. So remember, it is your decision who's going to get your assets, and having a will makes sure that your wishes are carried out. One of the, my office client was in and asked me the question, do I have to treat all my children equal? I goes, no, it's your call on what you want, what's your concern? And she says, well, one of my sons lives out in the West Coast. We don't hear from him much. I said, well, on Mother's Day, did he get a card or a call? She says, no. On Christmas, did he get a card or a call? No. On your birthday, did he get a card or a call? No. So I said, so you don't hear from this person for years at a time. Why should you leave him anything? But the most important reason for having a will is so that, I'd say, things go smoother, because a lot of times when there's not a will, it causes fights, arguments, sometimes even lawsuits amongst the family. So when people are grieving, let's say, and dealing with the loss of a family member, they shouldn't be overwhelmed and burdened with one more thing because something wasn't done. So we're going to talk about now.
Interrupt?
Who do you want you got to think about who you want to get your assets. Sometimes who you don't want to get your assets. I'd say, So now also beware of these online forms. Never use a form because a lot of times people don't fill them out right. And even though Snake Oil Online says valid in all 50 states, let's say sometimes it's not admitted to probate. So nobody smart tries to do their own electrical work on their home anymore. Nobody tries to change their own oil. Have a professional do it right. And a lot of times when you sit down with a professional, they'll discuss with you ideas on how to make things go smoother for the family. So
Hey, Ken?
I mentioned that there's a short questionnaire that's filled out. So believe it or not, New Jersey reduced the tax. Let's see, the New Jersey estate tax went away last year. There is no New Jersey estate tax. Let's see, there is a federal estate tax, but that doesn't start till over $11.5 million. So not too many people that are in like Woodbridge and Edison have $11.5 million. Now, it could come back in a couple of years. The governor's looking to try to find ways to spend money to go through all their plans and stuff like that. So, but at least now New Jersey doesn't have an estate tax. So that is important for everyone because our questionnaire used to be 10 pages long, asking a whole lot of questions about assets. Let's see, and now it's only 3.5 pages long because I don't need to know about people's assets. I ask them questions. Do you have more or less than $11.5 million? They say no. It goes, okay, that's you got good news and bad news. The good news is you don't got to pay any federal taxes. The bad news, you don't got to pay it because you got under $11.5 million. Now, our questionnaire asks who's going to be, who do you pick as executor 1 and who do you pick as executor 2? They'll sometimes say, well, I like to have joint. It goes, never have joint. That's terrible. That's the worst thing to do. There's a reason why there's only one steering wheel. There's only one captain of the ship. And even if they're twins living together, by having joint executors, you're creating twice as much work. 2 people got to go to the surrogate. 2 people got to sign the listing with the realtor. 2 people got to sign the contract. 2 people got to sign the addendum. 2 people have to sign every single check. So you have an executor 1 and an executor 2, and that's how it is. That's how it is best. And sometimes they don't agree. So you have one and then another. We do ask people in our questionnaire, where do you have real estate? Because New Jersey is a probate easy state. Other states are much, much more complicated. My mother-in-law used to call me every other year, oh, I want to have a trust done. And I would say, were you watching Susie Orman? And she says, oh, yes. He goes, Susie Orman is right if you live in New York, California, Florida, where the probate process is very complicated. But New Jersey, the probate process is easy. So I ask most people, why do you want to spend $3,000, $4,000 on setting up this trust and transferring your assets into a trust, when a $400 will do the job for you? But we do ask, where do you have real estate? Because if someone also owns property in another state, the main probate is in New Jersey where they live, but then there's a thing called ancillary probate in the other state. So if someone has a condo in Florida, I say, listen, you might want to put that condo into a limited trust while you own it. We next go into we never list assets in the will. And clients have said, why? I said, because you can't prepare a list of what assets you're going to own on the day you pass. Also, a will is a public record, so you never want to have something in the public that has account numbers, and it's not a public record until someone passes. Just let me make that clear. Now, a will takes care of assets that do not have a beneficiary. but certain assets do have a beneficiary and a will cannot change them. What are some of those examples? Well, the most common is a house owned by husband and wife. If it's owned husband and wife, automatically goes to the survivor. That's called tenants by the entirety. A will cannot change that. I hope that April can hear me, because I'm going to continue going. Let's see. Now, sometimes we have issues where assets are owned by what's called contract. Contract is where it goes, where there's a listed beneficiary. So examples of that are, let's say, IRA, 401k, life insurance, annuity, pension plan, anything that sets forth a beneficiary. And obviously things that pass by title, bank accounts, if it's payable upon death, that goes direct. And so then you want to set forth who's going to get your stuff. Let's see, so most people they want to go to their own family. Let's see, but you also have to set forth who's going to get things in the event that that person that you've picked has passed away. Let's say there's two kids. Typically it goes to children, and if one of them passes, to grandchildren, otherwise the other person. Sometimes though, people might say it's going directly to my children. Some people have what's called a specific bequest. That means that it goes directly to an asset goes to someone. So sometimes ladies will say, I want to have my jewelry go to my granddaughter. Sometimes guys says, I want my baseball cards to go to this person or that person. Now also, I think there's also a chat button. Let's say, so we're going to, I'm going to keep talking, and people can, I think, send me information through the chat button that the library set up, and I'll just keep talking.
Can you hear me?
No assets need to be listed in the will unless it's going directly to someone. Also, some people have, I mentioned that, you put that who's going to get your stuff. We have specific bequests. Sometimes I have what we call the reverse specific bequest. With that, it's where you're saying, I'm not giving anything to someone.
Can you hear me?
Hey, I'm not sure if April, who's from the library, can hear me.
I can hear you. Can you hear me?
I'm not a tech person, so I guess she can get back on and talk. Most people, sometimes someone will say, I'm not giving money outright to this particular person, but they're not going to get their money till later on. And I told April to call me, but she could either talk to me or call myself.
I'm gonna call you, Ken.
Anyway, life insurance goes to whoever you have as the beneficiary. Hold on, let me type in. Oops. April has my cell phone. She can talk to me. Oh, that must be library. Hello, April from the library.
Technical
Yeah.
And I'm being actually recorded.
Okay, well, don't say anything dirty, but
Yeah.
can you hear me but you
I
can't
can
see
hear
me?
you,
But you can't
but I
see me.
don't think you can hear me.
I can't hear you. I can only hear you from the phone. That's why I said call my cell phone.
Yeah, I didn't want to interrupt.
No, that's okay. I don't, again, I'm not, you know, because believe it or not, process in New Jersey is relatively easy. Well, it's not easy this very moment because the circuit's offices are closed. All that the executor of the will needs to do is bring the original will, death certificate, check for about $150 to the county office. See, and they meet with the surrogate. The surrogate, okay, looks, I see that it's what's called a self-proving will, and here's your papers. Sometimes other documents are not self-proving wills. Sometimes they're not properly signed. So think of the surrogate as a fancy name for the will clerk. If it's not the will clerk, if they don't accept it, someone has to spend $3,000-4,000 spending time, hiring an attorney, going to court, and doing a lot of work. So there was the old way of wills was person signs and then there's two witnesses, and then one of the two witnesses had to go to the surrogate's office and sign paperwork. Well, that became cumbersome because sometimes you couldn't find the witnesses. So there was a change in the law to say that if the person signs, then there's two witnesses, then there's an attorney or notary, then the person signs again, and there's language we take from the self-proving will statute. The two witnesses sign again, then the attorney or notary signs again, and therefore it dispenses with the requirement of finding witnesses. So it's always best to have a self-proving will. Therefore, you don't have to go through this step. And sometimes these things online are not self-proving wills. So that means that if it's not a self-proving will, the people have to locate one of the witnesses. And if you can't locate it, some of the surrogate's offices, well, then you got to file a complaint, order show cause to admit the document to probate. Also, when people are doing things on their own, a lot of times they don't do it right. And remember, only the original will can be admitted to probate. A photocopy of the will cannot be admitted to probate. So, I tell people sometimes a photocopy of the will is just as valuable as a photocopy of a $20 bill you lost. You can't go to the bank and say, "Hey, I lost my 20. I need a copy of that." Who keeps the original will? Well, the original will is your property. So, in the old days, the attorneys they were going to keep it for safety, but it was really so that people would try to get represent the estate down the road. So, and there was a Supreme Court opinion that said that, again, wills are property of the client, and therefore the attorney should only be keeping it if that's what the client specifically wants. And me, I don't want to be responsible for people's things anyway. So now, even though and there's no registry of wills, there's no wills are taken home by the people. Where do you keep your original will? Well, it's best to keep it in a fireproof box under your bed, because typically the area under the bed goes to waste and you're never there. No one goes under the bed until the house is sold. Don't put it in a safe deposit box. Why? Well, let's say you can't get to it. Let's say if you had your will or documents in a safe deposit box, the bank's been closed for 2 months. Also, a lot of times banks get taken over. I'd say I was put on my dad's safe deposit box. one day I went to the box and the bank changed names, changed ownership, and they goes, "Oh, you're not on the account." He goes, "No, listen. If my father went here, I know he filled up the papers, but they were just Wells Fargo sloppy, and they just lost the papers." So now, probate again in New Jersey is easy. Let's say after someone passes, say the surrogate. Think of this: the surrogate's the name for the will clerk. We call it. Even while the surrogate's offices are closed, they're like making some modifications where we can fill out a form ahead of time. We email the form. Then we also email or fax a copy of the death certificate. We email or fax some other information, and then the surrogate looks it over and goes, "Okay, we will admit it to probate as soon as then we get the original will and original death certificate." So first we or email, and then the clients or express or UPS to make sure that there's some tracking numbers, the original stuff. Then the surrogate will issue what's called letters testamentary, and that puts the executor in charge. We have to send out a notice of probate to everyone that would inherit, where they're that's in the will. And then after the surrogate's out of the picture for most of it. So what do the next couple do? Well, house gets listed for sale. Now there's no inheritance tax if assets are going to children, grandchildren, parents, but we still have to file an inheritance tax return. If it's going to brothers or sisters, the first $25,000 is tax-free. If it's going to charities, that money is free. Any other humans, though, it's taxed at 15%. Once the assets are liquidated and the inheritance tax division approves the return, then the executor will prepare an informal accounting. It's sent to all the beneficiaries, and with a form called a release and refunding bond. If all the beneficiaries sign the release and refunding bond, they get their money, and the estate is over. Pretty easy. Other states, again, New York, California, very, 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 very complicated. Sometimes, though, in the will, now I mentioned trust. Most people in New Jersey don't need trust, but sometimes within a will, there's something called a testamentary trust. And that means it's not funded, but there could be grandchildren that the money is going to be held for them. People with minor children oftentimes say they don't get their money until they're 22, 25, and 30. But someone is a family member becomes the trustee and puts the money into an account at Merrill Lynch, Morgan Stanley, make sure that their bills are paid, make sure that college is paid, sometimes buys a car. But we don't want to have, minors. We don't want to have we don't want to have, like, let's say 20-year-olds getting big chunks of money, because a 20-year-old does not invest money wisely. So think about, people who do you want to be holding the money for your grandkid in the event you weren't around. And by the way, how are we signing documents now? Well, people either go to a notary at the UPS store, or my office. We're signing documents in the parking lot. We put up a table. We schedule signings once a week, and that way, we just say you sign here, here, here. We have witnesses in the parking lot, and then afterwards, we say, okay, have a seat in the car. We're going to make copies and bring it out to you. Hopefully, the crisis will be over by the time winter rolls around and it's cold again. So, I mentioned wills, and wills are essential in New Jersey. Don't try to use one of these cheap forms online, because many times you won't do it correctly. The next document I'm going to talk about is powers of attorney. Let's see now. A will takes care of your assets if you pass away. What's a power of attorney? A power of attorney is a document while you are alive, where you're giving the power to a family member or someone you trust to make sure that your bills are paid. They can sign your, they can pay your bills, access your accounts, etc. Now I also, say there was a change in the law on powers of attorney, where some of the banks weren't honoring good powers of attorney. They were trying to say, well, it wasn't done on our, Wells Fargo form or Countrywide form. We're not going to honor it. So New Jersey legislature came up with a law to say, listen, if it makes reference to New Jersey statute, the bank or institution that does business in New Jersey had to honor it. However, it had to make reference to the New Jersey statute. It had to make reference to Section 2 of PL 1991, C95, C46:2B-11. And a lot, I'm pretty sure these cheap or free forms online don't mention reference to the New Jersey statute, and banks will not honor it. So, a power of attorney typically gives the person you picked as your agent the ability to make sure if real estate needs to be sold, real estate can be sold. They can pay any bills. Also, we added a clause under the HIPAA statute that it authorizes them to talk to doctors and look at the medical records, and have access. Most importantly, have access into bank accounts. Now, the power of attorney is effective either right away or only upon disability. Let's see. So most people, especially married people, make it effective right away. There's no need to, so if it's effective right away, for example, it's called a durable power of attorney, stays into effect if you become incapacitated. A springing power of attorney is not effective until you become disabled and there's a certification by a doctor that you are incapacitated. But we had a client that said, Kenny, let's say, I'm a carpenter. I don't understand durable and springing. Give it to me in carpenter terms. I'm a carpenter. He goes, okay. Number one, effective right away means your son can steal all your money right away. If it's effective only upon disability, your son would need a note from a doctor saying you're incapacitated, disabled before he steals your money. Knowing that, you trust your son. And the fellow said, I trust my son with my life. Okay, then make it effective right away. So now, what we have been recommending people do recently, especially while banks are closed, institutions are closed, we're trying to improve what we're doing is after the documents are signed, scan and forward them to every bank you do business with, forward them to the full institutions and Am I back? Can you hear me, April?
Yes, you're back. I'm April's assistant. We can hear you.
Okay, I just want to make sure. Every once in a while, I worry that I'm just talking into a screen. You never know.
There's like a major outage.
It's always glad to help out the Woodbridge Library. Yes. Scanning is good. Are we not on? It says
you cut out for a second, but now you're back in. So keep going.
All right, I'm keep going. So if anyone's writing stuff down, after you sign your power of attorney, have it scanned, send it to your kids, unless there's secret stuff you don't want them to know about. But that way, it's there. You send it to instant, because it's easier to be able to help someone out and use it if the Merrill Lynch broker knows that you're there to, help out mom, help out dad, or help out the brother, etc. Now, a will is valid forever. Sometimes you might want to make changes to it. If the executor, can no longer drive, no longer can get around. Our rule of thumb is someone should not be the executor if they can't walk up, 5 steps and they can't drive around. The same thing with the person you've picked in your power of attorney, because the whole idea is them to help you. We love our spouse, we love our family, but if the person that we picked can't drive to the bank to do the job, then is there someone else who is can do it? Also, it's a good idea to re-sign the power of attorney every 5 years or so, especially if the person you picked has moved and has a different address, because occasionally, someone could have a power of attorney that is prepared by your family's attorney, but then the daughter goes to the bank to try to help out mom, and the bank says, but there's a different name on this and a different address. And the daughter says, well, that's my maiden name, and I moved, to Monmouth County. Well, the banks are difficult to deal with when everything is fine. The bank is not going to honor a power of attorney right now if the person who's showing it on a screen has a different address, different ID, etc. So look, if you have the power of attorney, look at it, and you don't have a power of attorney, then you should get one done. And it's obvious to the family. Okay, the last document we're going to talk about is the Living Will Advance Directive. People have heard of the Terry Schiavo case and the Karen Ann Quinlan case, where someone was on, life support, and there's a battle amongst the family as to what to do. The idea of having these documents signed ahead of time is so that there's no battle amongst the family, so there's no hassle, there are no problems. And really, the living will isn't for you, it's for someone else in the family. So it's easy to think of the scenario where all of a sudden someone's, at the end, they're in a coma, irreversible condition. They can't open up their eyes, they can't talk. And this way, you're giving instructions to hospitals and doctors ahead of time. Hey, this is what I want. Please respect my wishes. There was a time where a doctor, said to me, because I had the power of attorney, but the person didn't get a living will done, and then the person's, at the end, and the doctor basically says to me, like, okay, should we remove life support? And you know what the right call is for someone who's 92 years old that's never gonna, regain consciousness. But you hate to be the one to say, okay, doctor, let's end it today. You feel bad. I couldn't even do it on my dog. When my old dog was like, so sick, and we were spending thousands of dollars with the vet, but I still could not be the one to say, okay, today's going to be the dog's last day. So in the Living Will Advance Directive, and by the way, if anyone has any questions, our Woodbridge Library has a chat button, because we're only supposed to go to about 7:45 or so. Anyway, the Living Will, the first section, there's an area that asks questions on fluids and nutrition. So typically, most people, probably 80% now, say, hey, listen, if there's no hope for me, I don't want to be on feeding tubes and things like that. But it's someone's decision on what to do. Now, some people were scared, saying, well, does this mean that, I wouldn't be, if I had a heart attack, nothing would be done? No, they're always, if you're at home or you're at ShopRite, of course they're gonna, do their best to, put you in the ambulance, bring you to the hospital, etc. But let's say someone has some kind of terminal condition, and the doctor says, okay, they got a week to go. The priest is giving the last rites. you know, you can give these instructions to the doctor saying, listen, I don't want to be on feeding tubes. The next section of living will deals with what we call like a medical treatment and artificial means. So 99% of the people say, if there's no hope for me, I don't want to be kept alive if my body is gone. Again, there's difference between someone all of a sudden goes to the hospital and the doctor says, hey, we got to get this person on a ventilator. Hey, that's fine. But on the other hand, someone who's like, 96 years old and they also have, leukemia, they got MS, and the doctor says this is the last week. Well, so, but it's an important document to have. Ironically, when I was first getting married 30 years ago, my wife said, oh, if something happened to you, I could never let them pull the plug. So I said, okay, fine. I'll just leave my dad because he's logical like Mr. Spock. So then you go like 25, 30 years in the future, and my wife would be instead saying, so, okay, if he passes, I get $800,000 of life insurance tax-free. Okay, they have, there's different things that people think about when you're been married 30 years. We revised our medical forms, our living will forms to have a HIPAA authorization. So you're authorizing your medical power of attorney to be able to talk to doctors. And the last page of the living will advance directive to ask questions about organ donors, yes or no. And I like to explain to my clients that I went to an interesting program put on by the NJ Sharing Network. That's the entity in New Jersey that facilitates organ donation. I asked the question, raise your hand. He asked the question, I said, but I goes, what is the maximum age to be an organ donor? And they said there is no maximum age. So I said, well, what's good on an 85-year-old guy? And they said like, cornea and skin. I goes, well, I never thought about that. If I was going blind, I'd rather have old guy's eyes. If I was in a bad fire, I'd rather have old guy's skin than the stuff that got burned off me. And I also asked the question, I go, what diseases disqualify someone from being an organ donor? Because, to be a blood donor, the list of disclosures is 18 pages long. But at the time, the disqualifier to be an organ donor was HIV. And ironically, a year ago, they took that away. Someone with HIV can be an organ donor to someone else that has HIV. So, let's say if someone needed a kidney transplant, their partner could say, hey, listen, let's say you need a kidney. I got two. You can have one of mine. I have HIV. You have HIV. But, I'd say you can have one of my kidneys. Now, the living will, you should give copies of the living will to your family. You should give copies to your doctor. So it's also a good idea to scan your living will. And that was, I scanned my living will and I sent it to myself on an email. This way, I could be at a traffic light and I could look up the email on my cell phone where I sent myself my living will, and I have it there. I'd say, and that's smart to do. I also emailed me my insurance card for my car in case I can't find it. I even emailed my American Legion card and my Elks card. So if I'm ever at a place and I need to prove I'm still a member, at least I have a scanned copy on my phone. So we've covered 4 main topics. I covered wills. I covered probate. Covered power of attorney. We covered living will, and I also covered a little bit about trust. Most people in New Jersey don't need to have a trust because the probate law is easy, and there's no New Jersey in estate tax. Some people, though, their trust does benefit if it's a second marriage situation. You don't want to give everything to your second spouse, hoping that they'll share it with your family. Some people set up trusts where it's called an irrevocable trust, and that's to shield assets in the event you have to go into a nursing home. But an irrevocable Medicaid trust, it's a 5-year look-back period. And I see that we are now past 7:45, so I thank the people that were paying attention. Does the Woodbridge Library have any comments or any questions you want to ask me? I see that there is a question in our chat, so I will look at that. Let's say, if someone is getting a house in a will, there needs to be a new deed. Just like if someone got divorced and in the divorce decree it says they get the house, well, that's only an agreement between their ex and that court system. Until there's a new deed filed with the county clerk's office, there is no record of who owns the house. So when property is transferred, there's a deed, affidavit of title, seller's residency certification, affidavit of exemption because you don't have to pay the taxes, and there's also a cover sheet, and the filing fee with the county clerk is about $150. And also it has to reference the reference when someone became the executor. But make sure you do it now. Just yesterday, someone called me up and they said, Mom inherited the house from her mom, but when her mom died 5 years ago, but she never did anything. And now Mom herself is in the hospital. He goes, well, that's a problem because Mom can no longer act as the executor, and we're going to have a substitute executor put in to do all the work on transferring the assets. Okay, Woodbridge Library, any other questions?
Does anybody have any other questions they'd like to ask in the chat? Maybe, Ken, you could just talk briefly if COVID-19 has any effect like on the courts or how things are operating right now. I don't know if everybody's from Middlesex County, but maybe a focus on Middlesex County just to make people aware if they have any issues.
Well, what our Middlesex County surrogate is doing now is they have where you're setting there's a mechanism where we fill out a probate information. We can't go into the building. We fill out the probate information sheet. I'd say I fax or email the death certificate, the will, the information sheet. Then the surrogate emails us back papers that have to be signed in front of a notary, and where the person who's going to be the executor has accepted the duties. Then the person has to send in the original will and original death certificate. We send them copies, then the original goes in. In one of our matters, the executor says, listen, I don't trust the mail. I don't trust UPS. I don't trust Federal Express. I'm going to hold on to this until they open where I can physically hand it to the person. That way I know it's a done deal. And I says, okay, that's fine. There's the court system. They are doing what they can through Zoom. So if there was a dispute, and someone filed a complaint or to show cause, the judge will say, okay, we're going to have a hearing. The judge who's handling probate is in his den at his house. Everyone else is on their computers looking like we are tonight. And the judge here, swears people in, having them raise their hand. Everything's recorded, and they're doing hearings that way in probate matters. They waived some of the requirements in guardianships, where someone is incapacitated, where they didn't have a power of attorney, because it used to require that there be two doctors and then a personal visit by the temporary person. But if you're the temporary guardian, you can't go into the hospital or wherever the person's at, the care facility. They're in lockdown. So we're hoping that, by the end of the summer, they're going to have live hearings. The court's resources are stretched, so they have to handle the emergent matters, and they also have to handle the criminal matters for the people who are locked down. Any other questions, April?
There is another question in the chat. I don't know if you see it. How can I protect assets from catastrophic medical expenses like rehab facilities, assisted living, etc.?
Let's see. So how do you protect? I always get, a lot of times it's the kids that want to protect their parents' assets so they can do inheritance protection. But if you want to protect your assets, let's say there's Medicaid is welfare. Who pays for someone's like catastrophic medical bills or like having to go to nursing home? Who pays for it? Either you pay for it yourself, or if you don't have assets, Medicaid pays for it, because Medicaid is welfare. So if someone was, 55, 60 years old, and they said, okay, I'm going to set up this irrevocable trust. Let's say I'm going to then retitle the assets where I don't own it anymore. It's going to be owned by the trust, and then someone else has to be the primary trustee, because you can't have full control over the trust. Then 5 years go by, then that would protect the assets from Medicaid. But again, most people, it's very difficult to try to convince someone who lived through the Depression to say, listen, I have a good idea. You should give all your assets into this trust or give them to me for safekeeping. But it's better to set up a trust than to just give it outright to children, because you can't guarantee that they'll still be, the kids or the kid's family will still be with you. So a quick example is, Mr. M decided he didn't want to spend the money on setting up a trust. Instead, he just gave his daughter half of his stuff, his son half of his stuff. He did a new deed. Half of the townhouse went to the daughter, half of the townhouse went to the son. And he goes, okay, good. I saved this $3,000 on doing this trust. Well, unfortunately, what happened was his son, who he gave half of everything to, died. So then after the son died, who now owned half of everything this man had? Well, the son who's died's wife. And that's her money. It's in her name. It's in her bank accounts. And the family sent a letter saying, can you do us a favor and send us back all the money? And I represented the daughter. She goes, what do I have to do? I goes, you don't need it. That's yours. That was your husband's money and now yours. So that's one of the rare examples where someone may benefit from setting up an irrevocable trust. All right. Any other questions, Woodbridge Library?
There is another question about transferring a house into a trust and recording the deed.
So the interesting thing is, every mortgage has a clause that says, thou shalt not transfer this property to anyone else. And if you do, then they can declare the mortgage due, and if they can foreclose on the mortgage. So every once in a while, a mortgage company will permit it to be transferred into the name of an irrevocable trust, but that is very rare. So when people say, I want to transfer the house into a trust, I go, well, okay, good luck on trying to convince the mortgage company to permit that kind of transfer. And I had a client say, well, how's the mortgage company going to know? I goes, because they know everything. I'd say, they get reports on who got on transfers, and it gets reported back to the to the mortgage company. So if the mortgage companies want to let you do it, hey, get it in writing. That's the important tip. Get it in writing. Even in probate matters, sometimes everyone has an agreement on what everyone's going to do. They agree that so-and-so is going to stay in the house. I say, good, get it in writing. Have everyone agree ahead of time, because, we've had litigation where they thought everyone agreed, but, everyone didn't agree. So if it's in writing, that protects you. Let's see. Okay. Did that answer the question, Woodbridge Library?
I think so. There's another question about a stimulus check.
Oh, the interesting question. I don't know the answer to that, because my dad asked me that question last week. And I said, well, I'd say, my mom passed away. My dad gets a stimulus check. Mom gets a stimulus check. He says, what should I do? I goes, let's wait to see what the government says we have to do. But I told him, don't spend it, because you may have to give it back. I wish I knew that is a federal government question. And that's one of their downsides of just sending money out without, looking. And all right, any other questions, Woodbridge Library?
Does anybody have anything else they'd like to
Any other
ask?
questions?
Anyone? I'm going to drop Ken's information, or I'm going to try to share Ken's information. If you just hold on, just with his website and information, if you wanted to just, take that down. I don't know if you can see, Ken, it's just your website, phone number, contact information.
Oh. I'm on Woodbridge Avenue in Edison, right? That's the same street that Woodbridge Town Hall is on. So I'm not that far away. I went to high school in North Edison, so I've been in this area for a lot of years, and I put on these programs with different groups. I'm a volunteer, and hope that the information was helpful to everyone.
Ken is really easy to find too, because his website is just njlaws.com. So it's a real simple website. And if we don't have any more questions, I'm just going to stop the sharing on this screen. If we don't have any more questions, I'm just going to thank Ken for all his work. And I'm sorry about the whole video issue.
We're learning. Now, hopefully in the fall, we'll be back to like live everything again.
Fingers crossed.
Okay. Thank you, library. Be well.
Thank you, Ken. Thank you to everybody for tuning in. Have a good night. Thank you.
Bye.